Morning, everyone. Welcome to Local Government Transparency and Ethics. It's 9:30 on the dot, and every minute is precious with us today. So one bill on the agenda, the House Bill 2433, clarifying county authority over the transfer or appropriation of water by placing such authority, except for domestic use, with the chief engineer and water transfer hearing panel. So Jason, you get to kick us off. And committee, just remembering we have Jason with us. If we have questions, we can catch him later about it so we can keep moving on. So thank you, Jason.
Thank you, Madam Chair, members of the committee. Yes, House Bill 2433 amends the County Home Rule Statute 19-101A. Counties generally can exempt themselves through their statutory home rule authority from acts that are non-uniform in their application to counties. 19-101A obviously provides the exceptions to that general home rule authority, and House Bill 2433 would add a new exception to that exercise of home rule authority. It's on page 4 of the bill, starting in line 9. This deals with the appropriation and transfer of water. Generally, that's governed under Chapter 82A of the Kansas statutes annotated. To the extent that those provisions are non-uniform in Chapter 82A, House Bill 2433 would prohibit counties from exempting themselves out of the non-uniform provisions and imposing their own regulations regarding the transfer and appropriation of water. This would include requiring any type of license or permit, imposing any conditions, limitations, requirements, or fees to transfer or appropriate water. There is a carve-out that would allow counties that could still adopt zoning and sanitation regulations to regulate the location and use of domestic water wells, so that falls under standard zoning and sanitation regulations. The bill also provides that this prohibition has retroactive application to any existing county resolutions and their effect on past transfers and appropriations of water. I will point out the House passed this on a final action vote of 116-6. It would take effect on the earlier effective date of publication in the Kansas Register, so that would be before July 1st. As soon as it gets published by the Secretary of State, it would become effective. That I'm happy to stand for any questions.
Jason, you did that very well. All right, we'll save questions for you for later if the case. So committee and audience, my goal is we have 59 minutes if we try to get 1 minute to our next committee. So we're going to go until 10 o'clock with the proponents, and then at 10 o'clock we'll do the opponents. So that's about 2 minutes a person if you want to share your time, and we do have that noted on the agenda, or on my agenda, for some opponents sharing time. So I'll do a clock for 2 minutes, and you can paraphrase what your testimony is, and then we do want to save time for questions. That's the most important thing to us. So, and I'll be watching the clock really close for. So everyone, I know it's not as much time as you want, but it's the equal amount of time, so it's as fair as we can make it. So thank you very much. So our first proponent is Representative Barb Wassinger. Welcome to the committee, Representative.
Thank you, Madam Chair and committee. I am Barb Wassinger. I'm the representative for the 111th District in Kansas. The information that you've received so far is inaccurate. Let me set this record straight. Edwards County and Waterpack have waged a legal battle against the cities of Hayes and Russell for almost 11 years at the cost of over $10 million. Edwards County has lost every battle and have simply tried to block the cities of Hayes and Russell from getting the water they paid for and are legally due and should not have to litigate, and certainly not for 11 years. The chief engineer has authority over water rights in Edwards County and then over all of Kansas, and Edwards County did adopt all of the chief engineer's authority in their county zoning regulations. So they make themselves the water authority instead of the state of Kansas, which is statutory. Exactly the opposite of the intent of state law. It's not land use authority. It's duplicating state water authority, and this has a devastating effect. Proper local authority is specifically mentioned in the bill that put counties in charge of zoning and sanitation for domestic wells. That stays, that doesn't change, and it's reiterated in the bill. The city of Hayes uses less water today than it did in 1970. We have been the conservation poster child of the state of Kansas. We believe in water, we realize its value, and we're very careful with how we use water all throughout the city. This bill is necessary and not overreaching. Thank you, Madam Chair and committee. If you have any questions, I'll be here to stand for them. Thank you.
Thank you, Representative, and perfect timing. Our next proponent is Jim Cross, Mayor of the City of Russell. Good morning, Mayor.
Good morning, Madam Chairman Bowers and committee members. I am the mayor of the City of Russell, and I'm here to testify in support of House Bill 2433. This, again, is a clarifying measure of current state water law. It correctly belongs to the chief engineer and the water transfer panel. Kansas already has in place the transfer process. As it was stated before, Hayes and Russell are water conservers. We do everything we can do to utilize the water that we have. We are at the mercy of nature when it comes to our surface water, and we're not in excess of anything. We cannot grow our communities economically, and we are economic drivers in the central part of the state. For years, Hayes, or Ellis County and Russell County had the two largest oil reserves in the state of Kansas. We don't have that business anymore, and so we're trying to expand. We have Purefield in Russell, and they are planning a large expansion, and without the adequate water supply, that expansion will not occur. So they buy grain, they produce feed for cattle, so everything is there that does not take anything away from agriculture. So we are just asking that you consider passing this out of committee, House Bill 2433, and hopefully the Senate will be agreeable. Thank you, Madam Chairman.
Thank you, Mayor. And I'm going to take 10 seconds to introduce a guest of mine. My daughter, Dr. Haley Lowell, is in the back, and she is Doctor of the Day, so she popped in to see me operate, she said. So she can go backstairs and operate herself. But she is here probably mainly taking blood pressure today. So, and her specialty is delivering babies, and hopefully that won't happen in the building, but thanks, sweetie. Our next proponent, Mason Rudger, Mayor of the City of Hayes. Good morning, Mayor.
Madam Chair and members of the committee, thank you for allowing me this opportunity to speak in support of HB 2433. My name is Mason Reuter. I'm the mayor of the City of Hayes and a sixth-generation Kansan who's never left Ellis County. HB 2433 clarifies the state of Kansas governs the regulation and use of water in Kansas. It prohibits counties from attempting to duplicate state water law and regulation through local zoning codes. This legislation ensures the water rights across Kansas are governed by uniform, consistent laws administered by the statutorily authorized state agencies. If counties are permitted to duplicate state water law within local zoning codes, the result could be up to 105 separate, non-uniform regulatory processes that water right owners would be required to navigate in addition to existing state processes. Allowing counties to duplicate state water law and regulation also creates the risk that these processes could be weaponized against particular uses. Dairies, feedlots, power plants, ethanol facilities, data centers, public water suppliers, and other lawful water right users could be targeted, not for legitimate land use concerns, but through a duplicate water rights review disguised as zoning authority. Kansas law already recognizes this risk in other sectors. KSA 19101A provides explicit protection for oil and gas operations. Section 19 prohibits counties from regulating oil and gas activities that are governed by state agencies and statutes, and it prevents counties from requiring local licenses or permits for these operations. If uniform application of state law is critical for oil and gas, it should also apply to the regulation of water, our most precious resource. I would also like to briefly explain why this issue is not theoretical. The cities of Hays and Russell have spent 11 years navigating a comprehensive state regulatory process to develop water rights that we own, and Edwards County is a long-term sustainable water supply. Edwards County has legally intervened in this process, attempting to block the project. After a lengthy hearing, an administrative law judge approved the Hays and Russell Transfer Act in February 2024. In April 24, Edwards County amended its zoning regulations to duplicate Water Appropriation Act and Transfer Act within its code. HB 2433 provides clarity, consistency, and protection for water right owners across Kansas. I respectfully ask that you consider this bill for approval, and I will stand for any questions should you have any.
Thank you, Mayor. Our next proponent, Mike Parsons, Executive Director, Russell County Economic Development and CVB. Good morning, Mike.
Good morning. Madam Chair, members of the committee, my name is Mike Parsons. I serve as the Executive Director of Russell County Economic Development and Convention and Visitors Bureau. I'm here today in support of House Bill 2433 from the standpoint of rural economic development in Russell County and north central Kansas. From the economic development perspective, water is foundational infrastructure. Several impactful economic development projects are on hold currently due to the uncertainty of providing that infrastructure. If not addressed, population loss, business stagnation, and reduced workforce availability will continue to ripple outward into our communities that already face tight labor markets and limited economic margins. The cities of Russell and Hays have They've complied with nearly a decade of state-level review and have demonstrated that this project provides a statewide and regional benefit. In my opinion, HB 2433 ensures that long-term infrastructure improvements, especially those critical to economic resilience, are not undermined after extensive regulatory compliance and are not fragmented by local decisions. For those reasons, I respectfully ask for your support of HB 2433. Thank you for the opportunity to provide testimony. And I'll stand for questions at the end. Thank you.
Thank you, Mike. Our next proponent on the list, Sarah Wassinger. I might have said that wrong. Wassinger, President, CEO, the Hays Chamber.
Yes.
Good morning.
Good morning, Madam Chair and members of the committee. As she said, my name is Sarah Wassinger, and I'm the President and CEO of the Chamber in Hays, Kansas. And I appear today on behalf of our 445 business members that are a part of our local chamber. House Bill 2433 reinforces Kansas's economic framework by ensuring that authority over water transfers and appropriations rests with the state agencies specifically charged with their responsibility, and that counties may not override that process. From an economic development standpoint, regulatory certainty is essential. We do a very extensive job in our community visiting with prospective businesses to ensure that they understand just how vital our water resources are and that they would be good stewards of our most precious resource. Independent analysis by the Docking Institute identifies Hays as the economic center of a regional economy that is important to the state of Kansas, with the primary region producing approximately $1.8 billion in gross regional product, resulting in significant tax revenue to the state of Kansas. The loss of vital resource such as water would cause serious population and industry decline and would significantly harm the statewide economy. Experts further estimate that without this project, drought-related losses to Kansas could reach as much as $251 million annually. House Bill 2433 protects infrastructure investment, supports regional economic engines, and strengthens Kansas's competitiveness. We respectfully ask for your support of House Bill 2433. Thank you so much for your time.
Thank you, Sarah. Sorry about catching your name wrong there at the beginning. Our next proponent, Toby Daugherty, City Manager Hays. Good morning, Toby.
Good morning, Madam Chair, members of the committee. Thank you for allowing me to speak today. My submitted testimony has a frequently asked questions section if you would like to refer to it. House Bill 2433 does not take away local control. It confirms state control over water appropriations and transfers. It ensures water right owners are not subjected to arbitrary and duplicative regulatory proceedings at the whim of a county. Water rights in Kansas are real property rights. Owners of these rights depend on a clear set of rules, uniform application of the laws, and a consistent regulatory environment. If regulatory oversight becomes uncertain and arbitrary, it will cause harm to everyone's property. House Bill 2433 clarifies oversight of water appropriations and transfers, and that is it. It doesn't affect the local government's ability to regulate its right-of-way or enact legitimate land use regulations. It does not prohibit local governments or residents from participating in state regulatory proceedings. It also does not circumvent any ongoing litigation. Hayes and Russell are involved in 2 lawsuits currently. The chief engineer has issued a master order governing the water rights conversion from irrigation to municipal. That was challenged in Edwards County District Court. The Edwards County District Court judge upheld the master order. It was appealed. We counter-appealed to the Supreme Court. The Supreme Court took it up, and there was a hearing in December on that. This bill has nothing to do with that whatsoever. Hayes and Russell have also filed a declaratory judgment action in Edwards County challenging the validity of their zoning regulations and their right-of-way permitting regulations. That lawsuit is currently underway, and that lawsuit is much more comprehensive in scope than this legislation. So if this legislation were to pass, it would not make that lawsuit go away. House Bill 2433 does not create new authority. It clarifies and reinforces the law as most believe it stands today, providing regulatory certainty, protecting established rights, and avoiding unnecessary and costly litigation. All water right owners in Kansas deserve clear and consistent regulatory oversight. And I thank you for your time and would stand for questions at the appropriate time.
So thank you very much, Toby. And we have one last proponent before we can move into questions. I put my agenda aside here. Let me look at your agenda, Ron. So we have Todd Lookman, Kansas Rural Water Association. Good morning, Todd. Oh, there it is.
Thank you, Madam Chair. I'm here representing, I'm an attorney in Topeka. I'm representing the Kansas Rural Water Association, an association of approximately 800 cities and rural water districts throughout the state. And I understand there is an overarching dispute that resulted in this legislation. I'm going to talk about a different implication that's also in my written testimony, and that is the interconnected nature of water supply systems in the state of Kansas. There is a web of connections between cities, rural water districts, public wholesale supply districts, and other special districts that supply water across county lines. There is no conceptual reason why a county now can't impose the same kind of restrictions that Edwards County has done here to stop supply of water between 2 cities, 2 water districts and cities. Some examples are Post Rock Rural Water District has one main water source in Ellsworth County, but spans 8 counties. The Wyandotte County Unified Government sells water to Leavenworth number 1, Consolidated 1. Leavenworth could stop that. Pottawatomie County number 1 sells water, or buys water, from the city of Manhattan. So Riley County could stop it. All these connections, there are a number of them. I could go on and on about them, but those interconnected systems can be harmed if you do not pass this bill. And the second thing pointed out is that there's an existing regulatory scheme that covers all aspects of water supply that each rural water district and city takes very seriously. And the state of Kansas has essentially preempted the field. That's a legal argument that may be for later, but we believe that there is a good regulatory scheme, and we would hope that this bill would be passed to support water districts and cities. Thank you.
Thank you very much, Todd. And that is the end of my list of our proponents verbally. You will find, and we have to compliment our Randy because she's worked really hard in putting all the testimony together. All of the written testimony is clipped together for us, and it's listed on our agenda. So at this, we have time for questions before we move to the opponents. Senator Fascido.
Thank you, Madam Chair. My question is for the gentleman from Russell. Is it Mason? Or, well, no, I'm sorry. It was the gentleman right after the mayor that spoke. The gentleman there with the red tie. Or,
Mayor of Hayes, yes.
yes.
Red tie. Nice
Russell.
look.
So usually we're talking about keeping local control. And you're saying for this legislation to keep state control. So can you just elaborate a little more why it's the reverse, the opposite? A lot of times people talk about local control, let them have it, but you're saying the water issue should be state. So can you elaborate?
Yes, and then if you have further questions, I can defer to Toby Doherty, who's
Okay,
a lot
thank
more
you.
information than I do.
Thank you. Or the representative stood too. Thank you.
Or we're like, whoever would like to answer the question? Is that-
I can give you something brief, and then I'll have Toby come up and answer in detail. So essentially, this doesn't change local control aside from keeping the authority where it currently lies statutorily. I mean, this actually removes any additional potential unnecessary and unrestricted red tape that any water right user would have to go through. I mean, state law is very clear on how the water transfer process is. So this allows us to have a uniform application of the law throughout the entire state of Kansas without it being completely broken up 105 different times. Toby, if you can explain on that.
Toby Doherty, Hayes City Manager. Senator Fascido, I would add that we don't view this as a legitimate use of local control. I would say most people that deal in water rights understand that the state controls and appropriates and regulates water rights and appropriations. And so if localities were to be able to, at their desire, randomly usurp that power, then why would a water right owner follow the state processes if they knew the county could come along in the end and do it? In this case, we spent $11 million in 11 years navigating a state regulatory process. If we would have known it was going to be duplicated, why would we have done that to start with? So there's this element of randomness to it. We're all about local control. Cities like local control, but we also want local control over those things we can control, not things we can't.
Senator Blue.
Thank you, Madam Chair. Toby, you want to come back up? And this is a question I think primarily, I don't know if you can also answer for Russell, since Russell is also part of this, but how much water do you plan to pump from the R9 Ranch versus what your permit's for?
So are you asking about the utilization when we converted the water rights, or like future utilization?
Future.
Okay, future utilization. So we have 4,800 acre feet on an annual basis of sustainable water there. Hayes uses 2,000 acre feet of water a year. Russell uses around 1,000 acre feet of water a year. Cities are actually limited to reasonable needs on how much water they can actually utilize, and it takes into account all sources. So even if we were to forego our existing sources, you're looking at 3,000 acre feet probably. We can't forego our existing sources. So I think initial look was around 1,500 acre feet a year, and then easing into it as we needed to with growth, or if we have a localized drought in our area hitting the property harder, or if there's a localized drought in the property we could hit and not ours, we could hit our existing sources.
And I have one quick follow-up. And I don't know if this is going to be a question for you, or it might be a question for Todd, but this is legislation not just geared towards Hayes and Russell, it's for statewide. Do you know of any other cities or counties that are in the same situation as you that maybe this legislation could affect currently or down the road?
I do not. Hayes and Russell is really the only metro area that I'm aware of that has water issues to our extent, that have had to look that far afield for water. So I'm not sure of anybody else in the same boat as we are.
Just to answer your question, this is a while back, but KRWA participated in a lawsuit in Trego County 30 years ago, where Trego County attempted kind of the same deal, and the court ruled against them. It was never appealed, so it never became a case that was reported and could be relied upon, but it has happened in the past and in other counties, Leavenworth County through different means, and Trego County are examples, so.
Senator Clifford.
Thank you, Madam Chair. I guess Toby will hit him again. What I'm reading here is, you're right, is about 8,000 acre feet. Is that, and you reduced that more than the 20% we're used to seeing?
So, so if you apply the consumptive use calculations for Edwards County, our water rights are 6,756 acre feet. That's what we would walk away with. But the chief engineer at the time asked us if we would do a modeling and determine sustainable yield of the aquifer. We used the Groundwater Management District Number 5 modeled the aquifer, figured out what was the most that could be pulled out from day one on an annual basis to where the aquifer is no better, no worse off in 50 years. And that number was 4,800 acre feet, so about a 29% reduction beyond what the regulations require. So we actually voluntarily agreed to that. That is written into the master order. And so when this is actually developed as a water source, that will be the yield limitation on us.
Follow up, Madam Chair. So that calculation kind of took into consideration the lack of recharge that irrigators might do in the local area because you're moving the water out of that area. Is that why you went even further?
We went further because, like many parts of Kansas, there are more rights than water in the area, too many straws in the aquifer. So the consumptive use calculation protects what would go into the ground if you were irrigating. So, you know, if you have 100 acre feet, I think in Edwards County, it's around 83%. You'd walk away with 83 acre feet as a consumptive use. That accounts for what goes back into the aquifer. We reduced it further because even at normal consumptive use number, it's not sustainable at that. So we agreed to reduce it by 29% below that to sustainable usage.
Thank you. Thank you, Madam Chair.
Senator Bowser.
Thank you, Madam Chair. Question for Mr. Luckman, please, our water attorney. And I think I understand the crux to the issue here, and I just want to make sure I understand Kansas law here. So I'm going to make a statement. The state of Kansas does regulate the appropriation, use, and transfer of water as part of its established water rights system, and that is derived from the Kansas Water Appropriations Act. Is that an accurate statement?
Yes.
Yep.
Senator.
And then under Kansas law, all water is sort of dedicated to the public. All water within the state is dedicated to the people of Kansas and subject to the state control and regulation. Is that also an accurate statement?
That's correct.
Yeah. Thank you, Mr. Luckman. That helps clarify. Thank you very much.
I don't see any other questions for the committee proponents. I saw our chief engineer in the room. Earl, could I pester you with a question? We don't talk about water law in here much, Earl. Can you state the name for our minutes?
Yeah, you bet. Thank you, Madam Chair. My name is Earl Lewis. I have the honor of currently serving as the chief engineer of the Kansas Department of Agriculture Division of Water Resources.
So my question, no other county has exempted themselves from state law from what you...
Not that we're aware of. Yep. And again, if I could, I want to make sure that we're clear. I'm not appearing here as a opponent. We're not taking a position.
I pulled you out of the audience.
Yeah, we don't think it's appropriate for us to try and tell you what we think our authority should be. But we're happy to answer questions.
When they change from irrigation right to a different right, correct, that uses less water?
Well, as Mr. Luckman just talked about, the consumptive use calculation, which is included in our regulation, is really meant to try and clarify how much was going back to the aquifer in irrigation. Because we think about municipal, industrial, or some other type of use, that's not going to have that same return of the water to the aquifer. And so we want to make sure that we're not increasing the consumptive use of the aquifer by allowing the change in type of use.
I have 30 seconds. My question just got away from me. Well, I'm glad you're in the room if it comes back. So we want to stay on time, Earl. So thank you for letting me grab you. All right, it's 15 seconds till 10 o'clock, so that's moved to the opponents. First on our list is Patrick Hughes, attorney, Adam Jones Law Firm, Wichita. Good morning, Patrick.
Good morning, Madam Chair, Senators. My name is Patrick Hughes. I'm a zoning and land use attorney in Wichita. I appear on behalf of Edwards County. I've written and taught seminars for Kansas lawyers on land use and zoning. In 2024, I assisted the county in adopting zoning amendments to address the local land use impacts of large-scale water transfer projects occurring in the county. Those amendments did not attempt to regulate water rights. They do not stop the Hayes project. They create a conditional use permit hearing process so that the county can evaluate and mitigate local land use impacts. Let me be clear. Edwards County doesn't dispute the authority of the state and the chief engineer to regulate water appropriation. The state regulates water rights. We respect that authority, and that authority needs no clarification. Our concern is that this bill goes beyond water rights administration, and it removes authority for the county to address localized infrastructure and land use planning impacts of these projects when they physically occur in our jurisdiction. The chief engineer regulates water rights. The county regulates land use, county roads. When a project requires heavy traffic, affects culverts or alters drainage, counties need to have mitigation, maybe bonding, to protect taxpayer infrastructure. The broad language of this bill would prohibit counties from using those traditional land use tools. Our zoning regulations are currently being examined by the courts. Hayes is the plaintiff, so the litigation is not all Edwards County starting it, and so far Hayes has been unsuccessful, but that litigation continues. What this bill seeks to do is to essentially preempt that litigation, tell the court what the ultimate result is going to be. This bill removes power from the local community to regulate the things that matter to the local community. The current situation is not that the county in Edwards County is attempting to regulate the appropriation questions that properly belong with the state. Thank you.
Thank you, Patrick. And next I have on the agenda, and you can tell me if this is true, Heather Strait, Executive Director, Economic Development for Edwards County. You'd like to defer your time to Patrick Jansen? No, okay, so sorry. A lot of confusion coming in from, okay, so you like?
Can I correct what you're mentioning? Sorry, I'm a little short here. Lyle Schutte has voluntarily given up his time.
Okay.
And we would like to defer that time to Patrick Jensen.
Okay, perfect.
Just to clarify that note.
Well, good. So Heather, you go right ahead.
Chairman and people of the committee, thank you for letting me be here. As she stated, I am Heather Strait. I'm Edwards County Economic Development Director. Edwards County is a population of less than 3,000 residents, yet we support 2 school districts, a hospital, many small businesses, and much more. However, agriculture is our background, is our backbone. Protecting that foundation is essential for our survival. This is why the adoption of ag zoning regulations was determined in 1997, not to block development, but to ensure that it's done responsibly. We are not trying to override state water laws. We are just asking for the right to review the major projects that impact our roads, right-of-ways, and tax base. The R9 Ranch Transfer is the first project of its kind in the state of Kansas. It will set a precedent for water transfer for following projects. If we remove local oversight now, we are not just affecting Edwards County, but reshaping rural Kansas as a whole. During the House testimony, it was stated that Edwards County only lost $5,000 in annual property tax. In reality, 44 irrigated circles were removed from production for this project, equaling roughly $176,000 per year according to our county appraisal's estimates. For a small rural community, that is not a rounding error, but that truly affects our schools, roads, and infrastructure. Hayes, Russell currently use 3,000 acre feet annually, yet allocations appropriate 4,800 acre feet, nearly triple their current use. Growth projections show that right now they're growing at 0.5%. So why is the level of pumping necessary? Why drain our aquifer and impact our region to have 3 times the current use of water? Finally, if this water transfer project can be bypassed by local zoning that sets the precedent for wind, solar, data centers, and much more projects that are on our horizon statewide. Local control is not an inconvenience. This is how rural Kansas survives. Please do not silence rural communities. I respectfully urge you to oppose House Bill 2433.
Thank you, Heather.
And I stand for questions when the time comes.
And we'll do that all in a group, so we'll make sure we have time for that. So thank you, Heather. Our next proponent, Josh McDonald, Partner and Chief Financial Officer, Blue Sky Farms, LLC. Good morning, Josh.
Good morning, Madam Chair and members of the committee. Thank you for the opportunity to testify. My name is Josh McDonald, partner and CFO of Blue Sky Farms, a family-owned business. We built Twin Circle Dairy in Edwards County, a 20,000 head dairy representing over $200 million in capital investment to date, 120 permanent jobs, and 22% of the milk supply to the new Hilmar plant in Dodge City, Kansas. Blue Sky is not opposed to water rules. We take water stewardship seriously. It is rural Kansas' greatest resource. Our water rights were converted under KAR 559, requiring a binding reduction in authorized usage. Our measured use runs below industry benchmarks. We purchase feed from area farmers, buying approximately 13% of the total corn grown in Edwards County. And the way we buy it, it's a little wetter, so it allows a corn farmer to reduce their irrigation by about 2 inches per year on thousands of acres in the county. So as an example, that those corn could generate around $800,000 in revenue, and we use the equivalent of 1,000 acres of corn, and that's the 800,000 comes from. And the dairy generates $173 million in local economic activity and 120 permanent jobs, all on the same water. So 200 times the output, 60 times the jobs, all by keeping the water in our county for economic development. We're building a biogas digester generating renewable natural gas, carbon credits, and fertilizer byproducts for surrounding farmers for decades. We are also evaluating an additional project to produce commercial fertilizer, reduce water consumption further, and eliminate odor entirely. Neither investment is possible without local control, and that local control is trying to be eliminated with House Bill 2433. The Hayes Pipeline exports Edwards County water with zero economic return to the community. No sane person signs up for that prescription. We worked hand in hand with Heather Strait, the Economic Development Director, the county commissioners, the zoning board, and the citizens of Edwards County at every step. The local voice was not a barrier to this project. It was essential to it. This is home rule working exactly as it should.
Josh, I hate to cut you off. I'd like to save some time for questions. Did you want to have a couple last sentences?
Sure.
I don't want to be rude.
So decades ago, I live in Texas, and decades ago in Lubbock, Texas, they acquired water rights from surrounding rural communities. I'm talking 50 years ago, and I can tell you the devastation in those local communities in our area is so evident, and so I just don't want to see Kansas go down that same path. So thank you for your time.
Thank you, Josh. Next, we have Jim Stanford, County Commissioner, Stanford County. Good morning, Commissioner.
Good morning. Thank you for having me this morning. My name is James Stanford. I serve as the County Commissioner in Stafford County, District 1. I'm in opposition to House Bill 2433. Kansas counties operate under KSA 19-101A, the Home Rule Statute. That law is not symbolic. It grants the authority to transact county business and exercise local legislative and administrative powers unless the legislature has clearly and uniformly limited the authority. House Bill 2433 does exactly what Home Rule was designed to prevent. It narrows long-standing authority over county roads and right-of-ways. Supporters claim this bill promotes uniformity, but Kansas is not uniform. Stafford County is not Johnson County. Land values differ, infrastructure demands differ, development pressures differ. The legislature granted home rule precisely because one-size-fits-all mandates fail on the ground. You may also hear that this bill protects taxpayers. Let me be clear. County commissioners are directly accountable to those taxpayers. If we fail them, they remove us. But when the state strips counties of the ability to negotiate effectively, the financial burden does not disappear. It shifts to local property taxpayers. Representative Wassinger has suggested this mirrors existing oil and gas home rule limitations. It does not. If we are going to reference home rule precedent, then it should be mirrored fully, preserving zoning authority, county oversight of infrastructure, and local responsibility for county impacts. This is not about resisting reform. It's about preserving meaningful local discretion over local infrastructure. Local control in Kansas is not a slogan, it is written into statute. I respectfully urge you to reject or substantially amend House Bill 2433. Thank you, and I welcome your questions later.
Thank you, Commissioner Jim. And according to my agenda, Lyle Schulte was next, but he's going to yield to Patrick Jansen. But next on the list in order is Bob Ryan, President, Kansas Natural Resources Coalition. Good morning, Bob.
Madam Chairwoman, members of the committee, thank you for your time this morning. I will be brief. My name is Bob Ryan. I am the chairman of the Board of Commissioners in Pawnee County, Kansas. I am also the president of Kansas Natural Resources Coalition, which is a coalition of 35 counties in Kansas. We work on behalf of land use and various other things. Typically, we work at the federal level on behalf of counties. This issue has kind of had us step into the breach, so to speak. We have provided written testimony. I'll refer you to that, please. Also, Pawnee County has provided written testimony that speaks to some of the technical aspects. I think it's very obvious from listening to testimony that we are here because of one issue, right? And this is a water issue. Why are we using home rule authority to deal with a water issue, right? There's 105 counties. There's multiple cities. I don't know how many cities are in Kansas. This is a one-off. If the law is clear on water appropriation, why are we here, right? This is about land use. I can give you the perspective from Pawnee County. We're in between the two, right? And this is just happens to be that way. We have road crossing permits. We have all kinds of things that go into any project, right? Or are we supposed to see that? And the unintended consequences of using home rule authority to solve a one-off issue are unimaginable, right? So once again, I'll point you to our written testimony for comments. I just wanted to bring that up. I will stand for questions. Thank you.
Thank you. We do like extra time for questions. You gave us 23 seconds. Thank you, Bob. Next on our list, Patrick Jansen, Chair, Water Pack Board. And you have a little more than 2 minutes if you want to use that, if you'd like us to ask you questions. So you just proceed. Patrick, welcome to the committee.
Yes, thank you for the opportunity to provide testimony. I've been serving as the president of the Water Protection Association of Central Kansas. That organization was established in 1992. Everywhere I've heard the folks from Hayes talk, they refer to us trying to block the transfer. That is not the case. Our issue with the water transfer is the quantity of water to be transferred, not any dispute over the property rights, their ability to use the water, any of those things. The cities do lead the nation in per capita water efficiency, and we applaud that accomplishment. There's a number of deficiencies that our experts have found over the course of this process. One of them is, if you hear Toby talk many times, he'll refer to a layer of 100 feet of water below that ranch. Going through their plugging records last week, the actual thickness of that layer is only about 44 feet. That's just one inaccuracy in several that affect the total amount of water that they can remove from there safely, in our opinion. And at the end of the day, the citizens and administrators of Hayes have been misled about both the quantity and the quality of water on the R9 since its purchase. It's an extremely delicate resource of marginal quality water that must be managed correctly to avoid impairing both the cities and their neighbors in Edwards County. In a backdoor manner, WaterPack is actually working to protect the citizens of Hayes in this thing as well as the citizens in Edwards County. Rather than applying for the conditional use permits as required by Edwards County zoning, the city's filed suit against the county commissioners and the zoning board, both as regulatory bodies and as individual members. 14 lawsuits in total. They then drafted House Bill 2433, taking a shotgun approach to the entire state of Kansas in an effort to avoid playing by the rules in Edwards County. Again, WaterPack and Edwards County are not out to block the transfer. The transfer as proposed is not sustainable and ultimately will harm both the cities and Edwards County. House Bill 2433 is a bad bill intended to circumvent county government, reduce local control, and write another chapter in a story filled with bad science, poor oversight, and terrible precedents. Please stop the pattern of bullying, political cahooting, and either reject or amend House Bill 2433. Toby stated on the record that they only needed 2,000 acre-feet of water. If they would amend the orders, reduce that to 2,500, we will walk away from every lawsuit we've got pending and let them get to work. So that's my testimony, and I'll stand for questions.
Well, thank you, Patrick, and you did that really well and saved some time for questions, too. Next on the agenda, Mika Schwab, private citizen, and is on WebEx. Do we have? Yes? Well, good morning.
Good morning. It's Micah Schwab.
Oh, I'm so sorry. I truly messed that one up. So I'll start the timer for 2 minutes, and you go right ahead.
Oh, I appreciate it. So my name is Micah Schwab, Michael like the rock, Schwab like the Secretary of State. I am an attorney who represents friends and family and other clients across Kansas, including folks in Hayes. I'm married into a fifth-generation family farm located near Pratt, where we harvest fresh red potatoes that are shipped across the state, and I hope you've gotten to enjoy them because they are delicious. I'm here on my own behalf, not on behalf of any particular client, and I'm sorry I could not be there in person. I'm also sorry that you all got dragged into this. I've already submitted written testimony for the record, so I want to focus briefly on two principles that I hope will guide this discussion. One is county home rule, and the other is avoiding buy and dry. Let me be clear, though, at the outset, I am in favor of water transfers and in favor of water changes. Communities need flexibility, but these transfers have to be done correctly, openly, transparently, sustainably, and based on both demonstrated need and clear facts. My clients, my family, my friends, they span rural Colorado and Kansas, again, including folks in Hayes. And across that entire region, buy and dry projects look the same. You've got working land that is hollowed out, local communities that have been weakened, and decisions made by people who live far away from the consequences. In Crowley, Colorado, today, there are more prisoners than potatoes because they sold their water rights off to Front Range cities, and the only thing that's left is a prison. Now, much like Patrick, I want to correct a few things said by the proponents. You've heard references to an 11-year process, but this is not an 11-year story. This is a 31-year story that started when I was a junior in high school, beginning when the Circle K Ranch was acquired, long before this committee was ever involved. And along the way, Hayes and Russell actually tried to sell this ranch back to the state and did not succeed in doing so. This project became expensive, not because counties exercise local control, but because the water demand here is triple what they are currently using. This is the classic buy and dry model that other Western states are now trying to unwind and that they have figured out how to regulate through statutes like the 1041 regulations that are in play in Colorado. And let me be clear again, Edwards County is not trying to regulate water rights. What they are trying to do, and what home rule exists to do, is to manage roads, drainage, construction impacts, economic development, and public safety when large infrastructure projects are imposed on rural communities. Edwards County is also, quite frankly, worried about water quality associated with the ranch, and you should be too. We would not be here today if this transfer had been pursued openly and based on actual need.
I'm going to have you
Cut
wrap
me
up.
off.
So,
That's okay.
not cut up,
Available
cut
for
off, wrap up. So we do want you to stay on for questions. And by the way, we appreciate rural attorneys. So just so you know, we're working on getting more rural attorneys in our area. So
I'm one of them and proud to be one.
thank you. Next on our agenda, we have Carolyn Dunn, Stafford County Economic Development. Good morning, Carolyn.
Good morning. Thank you for this opportunity to present the views of Stafford County, not directly affected by this. We're not Hayes, we're not Edwards County. But the main reason we're opposed is that it would weaken local authority for every county in Kansas. Any county with meaningful water resources risks being pushed aside in future transfer decisions, no matter its circumstance or the needs of its residents. Kansas, with its strong leanings toward conservatism, prides itself on minimal interference from the heavy hand of government, making a law for all 105 counties, giving more authority to a state agency over local elected officials in response to a dispute between two communities is the opposite of conservative lawmaking. We're concerned about the unintended consequences when the state curtails the ability of local citizens to manage local conditions, land use, and community impact. Water in particular, a key resource on which communities depend for maintaining existing economic activity and any future development. It is especially important not to undermine the local decision-making when it comes to the installation of large projects that consume water. I think it would be useful to consider, I think this bill is not really even addressing the fundamental problem we have in Kansas. The fundamental problem is water scarcity. Water is a limiting factor when it comes to municipal growth, maintaining agriculture, and securing future growth in diversified industries. Without water, local communities lose tax base, existing tax base, and the opportunity to expand it. And we all know that property tax relief is a popular topic here as well. Instead of mediating between communities battling to move water from one deficit area to another deficit area, I think we would be wise to put our collective effort at the state level to secure water from water surplus areas outside of Kansas and pipeline it from those areas to where it's needed in local areas within Kansas, just as we do oil and gas. At a minimum, Stafford County wants to register its opposition to this legislation and respectfully asks the Senate to vote no, not only in this committee, but also to stand firm in any conference consideration of this topic. Please do not establish more layers of law and state agency control that lead to not good outcomes. Thank you.
So, thank you very much, Carol, and you did really well on time. Next on our agenda is Lynn Levine, private citizen. No? Do we have Desiree Petra? Would you like to save your time for questions, or would? Okay, well, wonderful. So we have your written testimony. So committee, we did really well. Now we do have time for questions, and I had Senator Titus first, and then we'll go to Senator Blue. Go ahead, Senator.
Thank you, Madam Chair. I'd like to start with Patrick Hughes. Thank you, Mr. Hughes, for being here. You know, I appreciate your testimony. I'm familiar with complex, comprehensive use or conditional use permits. My district has a lot of limestone extraction that takes place, and that also has a toll on roads. So I do appreciate the point of this, but in reviewing the regulations that the county adopted, which is sort of the heart of this, at least as it appears to me, only for water supply projects, the regulations are 15 pages. They're almost as long as the rest of the regulations just for these projects. And it has things in here like the socioeconomic impacts and the recreational opportunities of the project? And is the water being sent somewhere where there would be excess capacity? And your testimony says that, and most of the testimonies, this is about roads, drainage, and infrastructure, and most of this regulation doesn't deal with compensating the county for those uses. So it seems like you really overshot the purpose of conditional use permits with the underlying problem here.
It's always true that what we're looking to do with conditional use permits is to regulate land use planning generally, local land use planning generally. That includes questions of impacts on infrastructure, but the legislature has given broad authority with respect to looking at local land use planning issues. So what this regulation does is it gives the county the ability to get the information that they might need. It has processes in it to reduce that burden because it allows the Planning Commission to say, we don't need this particular type of information for this particular project that you're planning to propose. So the idea is, and this is actually regulation that is borrowed from a county in Colorado and then modified to better suit Edwards County. But the idea is to have an open process where we have all of the information that the Planning Commission needs in its quasi-judicial hearing to make recommendations to the County Commission about what to do. One of the things that we also find is in other counties, sometimes the issue is something different. Sometimes it is wind turbines or solar farms, or sometimes it is data centers. And what happens is those regulations, because that's the thing that they're concentrating on, are the ones that get the most focus because that's the biggest thing that they're dealing with. And so for Edwards County, their judgment was, this is the thing that demands our time, not everything else that might come in, and that's why the zoning regulations for that are more extensive than they are for other kinds of things.
How do you, so given that, and you keep trying to broaden this, but with the adoption of these in 2024 and duplicating almost directly elements out of the Water Transfer Act, how is the city of Hayes to interpret this any other way than them directly being targeted?
Well, it's true that the city of Hayes is the first water transfer project, and so by necessity, if you're going to regulate something, some area, it's going to be the first project that gets quote unquote targeted. But the concern is not merely this project, it is this process, right? It is the question, this process of taking of these kinds of projects, and that's why the regulations are targeted. We have particular size of projects for which you don't have to go through this hearing process, and others you do. But Hayes is the target only because it's first.
Well, I noticed you did exempt all irrigation and agricultural uses from these requirements. So I note there would be a number of those uses that would utterly fail to pass this test, but just an observation. Could I get one last question for Bob Ryan? And Mr. Ryan, you're sort of being, I'm using you as a proxy because there isn't a Stafford County Commissioner here. Or I'm sorry, Edwards County Commissioner here.
I'm Pawnee County Commissioner.
No, I understand, but Edwards
Okay,
County's not here, and you have the resource coalition that they're included in, correct?
Sure. Thank you,
So,
Senator.
just the perspective I take from this is, and this came from some of the EcoDevo testimony, I hear you guys strongly advocating that the county, each county should be able to determine how they want water put to beneficial use. Now, that's municipal use is clearly outlined, but my concern is, with those arguments, we're saying each county decides what's okay for economic use in their county. And that's going to vary from county to county. The dairy owner, a county could decide you shouldn't be able to use water for dairies. And I see the opposite side of this precedent as being really dangerous and taking away people's property rights. When you buy a water right, you have a list of things you can use it for. And your position seems to be, well, unless the county takes that away from you. And perhaps there's a condemnation issue there.
I think we see that differently, obviously. And like I said, our being an opponent to this is one size does not fit all, right? And if this authority doesn't exist for the county, then why are we here to strip it away? But then we add these other provisions that are land use issues, right? And with the one size fits all approach, stripping home rule, why are we not dealing with these issues? These issues are going to keep coming up, right? This won't be the last, is my opinion. Why are we not dealing with it in the Water Authority Act? Does that make sense? Well, our opposition is because we're trying to use blank one-size-fits-all home rule authority to deal with an issue that's, look behind me, pretty obviously on one case.
Thank you.
Do I have any other questions? Senator Blue, would you like to go? I know we're trying to get to our next meeting, but I don't want to stop the questions as long as I see someone, you're in the room. Go ahead, Senator Blue.
Thank you, Madam Chair. And my question is going to be for Micah because I think that he could simplify this. We've heard from the proponents that this matches oil and gas. We've heard from opponents it does not match oil and gas. Could you simplify why you believe it does not match oil and gas?
Sure. It is retroactive in effect. The language doesn't get anywhere close to what the oil and gas regulations say. It doesn't even get close to what the telecom regulations say for rights of way. And it goes much far beyond simply looking at conflicts between water appropriation or the Water Transfer Act. It is fundamentally focused, I think, on killing an ongoing lawsuit. And should it be passed, I think it kind of calls into question whether or not there's even lawful authority for it to pass, because this suit is pending in Edwards County right now.
And Micah, just as follow-up real quick, you have an amendment that you believe would match oil and gas?
Yep, I would actually just park it in the same provision of the home rule statute and just make the language mirror what's already in the oil and gas home rule provisions. And I think you have that, Senator Blue. I've also, I think, provided some language that would map to the 1041 regulations that Colorado has passed, which are a little bit more expansive, but also preserve the authority of the chief engineer, the Corporations Commission, and other folks that have projects that are involved with, that have a statewide impact like this one. Again, with an eye towards preserving that authority and making sure that water transfers are done sustainably and with proper facts on the ground and proper appropriate local control involved, not something excess or anything that's going to kill a project, but something that actually considers what's going to happen to a community so that you're not replicating by and dry.
Thank you, Senator Blue. Senator Clifford, no question. All right, we did really well on our time. Thank you, everyone, opponents, proponents, that we stayed with near our time frame. We didn't want to cut this off early, so we are moving to our next committee. So I'm going to close the hearing on House Bill 2433. That's our last item of business. Do look in your packets for a list of the proponents and opponents that are written only. So thank you very much, and we're adjourned.